any subsequent actions undertaken by the National Assembly based on the null and void acts of the purported public participation must therefore collapse. They cannot hold in law. Blatant disobedience of the court orders must be rendered null and void ab initio. My lords, my lady, I think I've kept my time. As the Latin maxim goes, fiat justitia ruat caelum, and for the benefit of our lay friends, let justice be done though the heavens fall. My lords, I will not proceed beyond that. And, the good Senator Agenda was muttering something when I said that I have my sisters, my learned sisters here. Yes, they're my sisters, Senator, but they're not available. Thank you, my lord. I hand over to my colleague, Mr. Muge.
Thank you. You are smart on time. We hope that subsequent parties will observe that trend which has been set. You asked for?
I had asked for, in total we're supposed to have 1 hour. She's taken about 10 minutes, I think.
25 minutes.
25 minutes. I'm going to take a much shorter time. I have agreed with my senior, Mr. Kibe, that I will be not donating 30 minutes to him.
Okay.
So, my lords and my lady, I proceed after my learned colleague, Ms. Minor, and I am in the unfortunate situation where the gravamen of our petition was public participation. And my lords, my colleagues before me have covered this subject quite deeply. So instead, I will essentially head into the nitty-gritty of what will be provided to you, has already been filed in court and will be provided to you by the respondents as proof of the exercise of public participation. My lords, as I considered these submissions, I was reminded of a phrase, rather a prayer, from my alma mater, Lenana School. And the prayer says, my lords and my lady, sieve the trash, dear Lord, we ask, for nihil praeter optimum. Nothing but the best. My lords, in regard to public participation, the intentment of the Constitution and of the citizens of Kenya when we promulgated the Constitution was that public participation must follow a process that produces nothing but the best. My lords, in that respect, there is a concept in computer science called GIGO. Essentially what it says is rubbish in, garbage out. GIGO. Also termed as RIRO, rubbish in, rubbish out. This is in regard to processes, and any process, my lords and my lady, that is put, that expects to have an output is highly dependent on the quality of the input, the quality of the process itself, and that will determine what the eventual output is going to be. So, my lords, keeping in mind this concept, GIGO, and the expectation pronounced and enunciated in BAT, I will not repeat all these authorities that have been placed before you the components enunciated in BAT, I would like to now, my lords, walk through each of the documents that will be placed before you. And we start with the Gazette notices that were published on 2nd of October. The Gazette notices were published on 2nd of October, 3rd of October. These are the advertisements. 2nd of October, 3rd of October, 4th of October, and finally, on 5th of October. My lords, this will be, you will find this in the affidavits, in the annexures to the affidavits of Mr. James Njoroge for the second, Mr. Samuel Njoroge for the 2nd and 7th respondents. Now, the first advertisement that was placed on 2nd of October, my lord, there was already an issue without advertisement. Why? Because one of the very first expectation under the components of in BAT is reasonable notice. This advertisement was placed on 2nd, notifying Kenyans that there's going to be public participation 2 days later. When Justice Mwongo on 3rd of October issued his order, he had taken into consideration the fact that 2 days was simply not enough, and he needed and directed that there must be more time given to the Kenyan public. 2 days. But my lord, looking at that advertisement, what was it actually doing? One, it provided venues, 47 venues. And this is important because what happened after that in regard to the advertisement issued on 3rd and advertisement issued on 4th were all amendments of the advertisement issued on 2nd. Now, already 2 days, 48 hours for public participation. My lords, we have been told, and you will be told by the respondents, that the reason that they decided to take just 2 days for public participation is because the Constitution provided that impeachment of the Deputy President is time-bound. And in regard to that, they will point to Standing Order 64.2, showing that Standing Order 64.2 requires just 7 days, and the exercise must be completed in 7 days, the whole impeachment exercise. And that is the reason they provide for using just 2 days for public participation. But my lords, when you look at Article 145 on timelines, you will note that the timeline, there is no restriction at all on public participation, on the time between the motion being moved and a resolution being passed. The time between a motion being moved and a resolution being passed, no time is limited. Limitation starts from when the resolution has been passed. That is the only time constitutional timelines kick in. So the reasons provided for limiting impeachment to 7 days and therefore curtailing the provisions of Article 10 and Article 118 do not exist in regard to public participation. My Lords, as I had previously stated, the second advertisement was put out on 3rd of October 2024. That Gazette notice made one change. It changed the venue for all the Kenyans participating in Nairobi, from KICC to Bomas of Kenya. My Lord, so what now has happened is that all the residents of Nairobi, based on an advertisement placed on 3rd, for public participation on 4th, to happen at Bomas of Kenya, have only one day. 2 days, my Lord and my Lady, was already limited. Now we have an advertisement of a different venue, 1 day. If 2 days was bad, 1 day is terrible. Then, my Lords, on the same day, the day scheduled for public participation, a gazette and another advertisement was issued. This time, 20 constituencies, pardon me, 20 constituencies had their venues changed. These were constituencies in Bungoma, constituencies in Nakuru, and constituencies in Meru. 20 constituencies being advertised and the citizens being told, you will undertake public participation today, and these are the venues. These are people traveling from all corners of these constituencies now being shifted and told public participation is today, you have 1 day notice. No, this time around you have 0 day notice. Public participation is today. 2 days was already bad enough. 1 day was terrible. 0 day notice was horrible. In regard, my Lords, to the orders issued by Justice Mongo for public participation as a second stage. My Lords, the orders of the learned judge were very clear. He stated that he would allow public participation to continue on 4th of October as the first stage, And he ordered that there shall be a second stage of public participation created as a new public participation exercise in keeping with all the components in BAT. Proper notice, not the 2 day notice. Proper information, not the lack of information provided in the Gazette notices. Proper structures, proper access, and most importantly, as a base, proper sensitization. What happened instead, my Lords and my Lady? On 4th at 10:22 p.m. and at 10:44 p.m., the clerk of the National Assembly drafted a press release, and that same press release was published in the Nation and the Standard. That press release, my Lords and my Lady, was for extension, my Lord, of the first stage, not a new stage. If you look at the affidavit of Jen Jeremiah, that would be in JNM 2, if I can find it, 1 second. This advertisement is on page 14 of the annexures to JNM2. It reads, notification of extension of public participation. My Lord, purportedly in compliance with the orders of the Honorable Justice Mwongo, the clerk of the National Assembly decided, no, we will not do a repeat exercise. We will simply add 1 day to the exercise that is already ongoing, which the Honorable Court already has issues with and has issued directions in regard to, and instead we will just extend it. And what does this gazette, this advertisement do, my lords? It does not, this time round, even bother to provide the grounds in which the motion seeks. It does not bother to include pullouts. It does not bother to make any attempt to provide any information, and simply makes the assumption that anybody that this advertisement is directed at will know what to do. It does not provide any venues and simply states there will be public participation at the constituency level. In the first, second, and third advertisements, there were 47 venues for the counties, specific venues. For example, Tononoka Social Hall for Mombasa, Kwale Cultural Center. They were very specific. But for the 290 constituencies, absolutely nothing. My lords, to compound the problem, the clerk and the National Assembly were clear in their minds that what would be required by the public in regard to sensitization and information should be provided. So what do they do? At the bottom of the advertisement, they provide a link to what they call the template. It is a link, and this is to the template. But at the bottom, in regard to the notice of motion, any evidence, and all the documents that they rely on, they provide at paragraph 5 of that advertisement that copies, and I'll read verbatim, copies of the special motion stating the grounds for removal and particulars of the allegations, together with the relevant documents, may be downloaded from the Parliament website. That is all. Telling Kenyans that you are invited to participate in this impeachment process, the evidence that you need to look at, the grounds that you need to look at, all the information that you require is on some website. We know that you will need this information, but you go look for it yourselves. It does not say that we will provide the information for you at the venues, and no proof has been filed in court to show that at any of the venues where public participation took place were the notice of motion and all documents pertaining and all particulars ever provided at the venues. That, my lord, is the failure of the Gazette notice itself. Then, my lords, if we look at the pullouts, what has been termed as a template. You will find one of the pullouts if you look at, if we look at page 235 of the annexures filed on behalf of the second and seventh respondents, again in the affidavit of Mr. Njoroge. I will be speaking to the affidavits in these, the annexures in this particular affidavit. My lords, if you look at this template, what is being called a template? It is purportedly a template to collect views. A template to collect views. My lords, from our understanding of what a template is supposed to be, is that somebody will take a template and then convert it for specific use. This is no template. My lords, if you look at it, it is nothing but a ballot paper. This ballot paper, being called a template, asks the people who will use it to make an election on a specific motion and on specific grounds, 11 of them. Paragraph 6 of this ballot, my lords, asks, what are your views on the motion? And tick, what is your vote? It is not a view. Do you support? Do you not support? And other, specify. This is a ballot question. It is not a view. Each of the 7 grounds provided from paragraph number 7 does exactly the same thing for each of the grounds. For the grounds themselves, no information is provided that could help my grandmother in Kimoro village, Nandi County, to understand what gross violation of Article 10(2)(a) is. It is an absolute impossibility. If she was to make that tick, it would not be based on any information. Why? She was never sensitized. She would not understand what she is taking in this ballot. And we will keep insisting that it is a ballot. My lords and my lady, and it is important that we note, at the end of this ballot paper is a date, and that date is important because there was a purported public participation exercise on 4th of October and another on the 5th of October. So we assume that for every form that was returned, it was signed and there was a date. There was a batch for 4th of October and there was a separate batch for 8th of October. And this will become important when we move to the report from Parliament on public participation. My Lord, I would like to make a note on the public announcement on 2nd made by Parliament on their social media. You will find it at page 239 and 240 of the annexures of Mr. Njoroge. And it shows that on page 239 that what they called as notification to the public received 125 comments, 19 shares, 203 likes. The penetration was close to 0. On page 240, I guess they decided to clip that out. Did not want to show it. So then, my lords, we've walked through the process itself on public notice and the template, the ballot paper that was used to gather views. So then, my lords, we move to the report itself. This report is a report that is supposed to show that indeed there was public participation that occurred. The bulk of the report that has been filed in court is pictures from 290 counties. And those pictures, I think, begin from page 296 of the affidavits that I refer to, Njoroge, and starts with the pictures and information from Ainapkwe constituency. And this, my lords, is where it becomes clear on what this exercise really was. For Ainapkwe constituency, at paragraph 61 of this report, it states that the public participation exercise took place at Ainapkwe NGCDP office. A total of 959 members of the public took part in the exercise. Of this, 808 persons indicated that they supported the motion, while 133 persons did not support the motion. Further, 18 persons expressed other views with regard to the special motion. Obviously, my lords and my lady, I did not belabor the point, but 808 persons indicating that they support is a vote. It is not a submission. But what is more telling is that the public participation exercise took place at Ainapkwe NG CDP office. You were not told when this happened. Was it on 4th? Because if it was on 4th, there was definitely no public participation at Ainapkwe. Was it on 5th? There is a possibility it would have been on 5th. But we are not told. From the report that you will see at table 2, actually table 3 of the National Assembly data, that table starts from page 436 of the annexures, which is a combined tally of all constituencies. You hear absolutely nothing about views collected at KICC, views collected at Bomas of Kenya, views collected in any of the 47 venues. All you will read is from number 1, Ainapkwe constituency, 970. Ainamoy, 756. On and on until the very last one, with the total being shown here, being 224,877 votes. None of them tell you when these views were collected. And this is the only evidence placed before you to show that public participation took place. A table that is unverifiable. A table that is unreliable. And my lords, this unreliability is deeper than just these numbers shown on this table. There were 11 grounds. You have not been told or shown how many people supported ground 1. Gross violation of Article 10 2A(b). Of the people that supported the motion, if they actually understood what they were doing, how many people supported ground 1? That information is not provided. We say because the information is not available. If it was, it would be before you. How many people supported ground 2 on Article 147? How many people supported any of the 11 grounds? My lords, you're not told this. Yet this is supposed to be the result of public participation in an impeachment process, and all you have received is ballot numbers, a count, no views at all. You are not told that in Ainab Koi we had discussion and were submissions, and 1 or 2 people or none stood up and said something. Absolutely nothing. My lords, those pictures that you will see show absolutely nothing but an election in makeshift ballot offices. My lord, if you look at page of the report again, going back to the report, and this should, page 286 of the report, consider this statement made at paragraph 58, page 286. It reads, and I need to repeat this, read this verbatim. At the close of the period for public participation as extended, a total of 38,065 submissions were received. And at A, via email, 7,106 submissions were made. Hand-delivered, 30,955. My lords, public participation ended approximately, let's say, 5 p.m. on 4th. Same time on 5th. Somehow, my lords and my lady, and this should make it clear that the information being provided to you is garbage. 30,000 Kenyans somehow walked into the National Assembly to deliver submissions to the clerk. My lords, even if each of these 30,000 Kenyans took 1 minute, just 1 minute, that would be 30,000 minutes. That is how long it would take. 30,000 minutes. Even with multiple clerks handling, it would be a total of 7 days to process that kind of bulk input. The only inference that can be drawn from these numbers, 30,955, it is fiction. As the rest of the tables are absolute fiction. My lords, from those numbers, from that information, it is clear that all we had was a count, a ballot, and unverifiable at that, So what is supposed to have happened with this information if indeed it was public participation and should have been considered by the National Assembly? I will direct you, my lords, to the Hansard, which is from page 1078. That's the Hansard starting in the morning at 9:15 a.m. for the morning session, and from page 1137 to starting at 2:30 p.m. My lords, I've made a summary because this is approximately 160 pages, and I'm sure you would not want me to walk through each of those pages. So instead, this summary, or rather the Hansard, provides the proof that even if something happened out there, the purpose of public participation should be that Parliament will consider the views of the public. Even if they disagree in the end, they must be considered. What did Parliament do? What actually happened in Parliament? My lords and my lady, at about 9:30 a.m. on 8th of October, the Honorable Millie Odhiambo tabled the report, the public participation report. This is the first time it has moved from committee, coming to Parliament for consumption. It is tabled at 9:30. My lords and my lady, what happens immediately after that? The motion is moved, and away we go. The report has not been considered. Debate, the motion is moved, debate starts immediately. The Honorable Millie Odhiambo is advised that she would have 15 minutes sometime during the day to speak to the report of the Committee on Public Participation. By the time she gets to speak to that report, 21 members of Parliament have already spoken without having had anything. In the afternoon, all the other members of Parliament, the honorable members, participate. And in total, the participation from them is 66 members speak, either in support or in opposition. And as you can see, the petitioner is at number 58 of that graph, and she opposes. But the damning evidence from this summary, and the whole Hansard, my lord and my lady, is that of all 66 members that participate, all 66, only nine members mention public participation or the views from their constituents. A whole day. Not any mention of the views from Mombasa County, from Kakamega County. Nothing. And the reason being, and it is rather obvious, that report sat on the table of Parliament with nobody touching it. Nobody looked at it. Nobody knew what its contents were. They had absolutely no opportunity to participate with it. my lords, I would like to leave it there. But in the end, if there ever was this exercise is a dead ringer for the concept of GIGO, garbage in, garbage out. My colleague, Mr. Nderitu, will handle the prayers. And as I said before, I donate my 30 minutes to Mr. Kibi.
You took 40 minutes. How much time will you take?
Just 2 minutes, my lord.
2?
Yes.
Oh, proceed.
Or even less. My lords, my lady, my name is Benan Nderitu. I shall be submitting on the reliefs sought on behalf of the third petitioner. Relief number 1. Your lordships, we are seeking a declaration from this court that the impeachment process conducted under Standing Order 64-2 violated the Articles 118, 145, 47, 50, and 10 of the Constitution. Relief number 2. Your lordships, we are seeking a declaration from the court that the modalities placed by the first respondent in respect to the public participation forums of 4th October 2024 fell below the threshold of proper, effective, and meaningful public participation as envisioned under Article 10 of the Constitution. 3, we are seeking that the modalities placed in regards to the public participation held on 4th and 5th October were in disregard of the court order issued in Kirogoya in petition E014 or 2024. 4, we are seeking a declaration that the public participation held on 4th and 5th October 2024 did not meet the constitutional standards under Article 118 of the Constitution. 5, we are seeking a declaration that the Senate violated Article 118 of the Constitution by failing to conduct public participation. 6, we are seeking a declaration that the impeachment process undertaken by the first and third respondent in view of the public participations held on 4th and 5th October fell below the threshold and therefore unconstitutional, null and void. This in regards to Article 10 of the Constitution. 7, we are seeking a declaration that the appointment of a select committee by the Senate is mandatory in the impeachment process of a president and a deputy president. 8, the proceedings in regards to the impeachment process outside the select committee were unconstitutional. 9, we are seeking a declaration from the court that the Standing Order 64-2 should be declared unconstitutional to the extent that it provides timelines which are not compatible with the constitutional requirements. 10, we are seeking an order of certiorari quashing the National Assembly resolution of October 8th, 2024. 11, we are seeking an order of certiorari quashing the Senate resolution of October 17th, 2024. And last of the reliefs, your lordships and my lady, we are seeking is costs to the third petitioner. I humbly submit. Thank you.
Thank you.
My lords and my lady, if it pleases you again, my name is Wamboi, Shadrach Wamboi. I appear on behalf of the 9th petitioner. My lord, what is before you is our amended petition dated the 28th day of October 2024. It is supported by an affidavit sworn by Ms. Dorcas Mwai, dated the 29th day of October 2024. My Lord, further to that, and in support of my arguments or our arguments, we have filed submissions and a list of authorities, both dated the 27th day of April 2026. And my lords and my lady, on our part, we will wholly seek to rely on our written submissions and the factual matrix that has been set by the deponent of the affidavit sworn in support of the amended petition. My lords and my lady, if you permit me, just briefly to highlight. My lord, the 9th petitioner being a public benefit organization, thank you. My lord, the 9th petitioner being a public benefit organization and speaking on behalf of the public indeed appreciates the opportunity granted by these proceedings, at the very least, to ensure that the impeachment process that was conducted leading to the removal from office of the first petitioner, His Excellency Rigathi Gachagua, from office, is one that is solely and not a political process, but is one that is a sui generis constitutional process that primarily is legal, though characterized by politics. Away from the political characteristic of an impeachment process, my lords, our duty as the 9th petitioner is to persuade you to making a finding that the process, as we witnessed on the 9th day of October 2024, together with the events of the 17th day of October 2024, leading to a resolution of the Senate to have the Deputy President, the former Deputy President, impeached from office, was done in haste, was done contra-constitutional. And my lord, as I shall demonstrate, the Senate, in our very humble view, appears to have walked over the very provisions of Article 145 of the Constitution. My lord, my arguments will be split into two. Firstly, I will wish to draw the attention of the court to the Hansard proceedings of the 9th day of October in an attempt to demonstrate to the court that the facts provoking the petition before court are not in dispute. It is not in dispute that the Senate, having had an opportunity of considering whether the motion for the removal of the Deputy President will be considered at the plenary or by an 11-member committee, opted in their wisdom to have the motion considered by the plenary. My lord, to that extent, the question that the petitioner will be urging the Honorable Court to consider is whether the very dictates or the authority that flows from a reading of Article 145(3) of the Constitution permitted the Senate to have an option on whether the matter should be decided by the plenary or the matter by the constitutional dictate ought then to have been considered by the 11-member committee. My lord, I make reference, express reference to Article 145(3), particularly 145(3)(b), where the Constitution dictates that the Senate by resolution may appoint a special committee comprising of 11 of its members to investigate the matter. My Lord, while the word may be interpreted to mean that the Senate had the discretion of opting to have the matter deliberated by the plenary or by the 11-member of committee, the position that we humbly hold with respect, my lady and my lords, is that regardless of the word may, the Constitution so demanded that the Senate proceed to have the matter heard and determined by a select committee or a special committee of 11, as opposed to having the matter decided in the plenary. My Lord, my persuasion or our persuasion to move the Honorable Court to making a finding that the use of the word may in this instant have given a command to the Senate to have this matter decided by the special committee is informed by the growing jurisprudence within the Republic of Kenya. Particularly, my Lord, I will wish to make reference to the Court of Appeal decision made in the year 2023, Civil Appeal, my Lord, number 3 of 2023. This is the case between the National Assembly and another versus Okia, Okoiti, Omtata, and 55 others. My Lords, with humility, I will wish to draw your attention to paragraph 145. Paragraph 145 of the said authority, where, my Lords, borrowing from the jurisprudence that has been set by the Supreme Court of India, are noted that it is settled that the word may is capable of meaning must or shall in light of the context, and that where a discretion is conferred upon a public authority coupled with an obligation, the word may, which denotes discretion, should be construed to mean a command. And my Lord, this Honorable Court has an easy task of interpreting the Constitution, because the very same document that you are called upon to interpret has already, under Article 259, given us modalities through which this Constitution should be interpreted. It should be interpreted in a manner that the Constitution is always speaking. So much so that by any reading or interpretation of the Constitution, then the Constitution should not be read to be speaking to us in a way that causes confusion in our interpretation, but in a manner that guarantees us clarity, in a manner that promotes the very values and principles of the Constitution and the human rights and fundamental freedoms of the person aggrieved. My Lord, going under or going down the reading of Article 145, is that there are certain safeguards that have been put by the framers of the Constitution to ensure that a party, in this case, either a president or a deputy president facing the motion of impeachment, enjoy certain safeguards to ensure that his right or her right to a fair trial is not run over. And this is by ensuring that the special committee, this is particularly Article 145(4), the special committee is mandated by law, by the use of the word shall, to investigate and prepare a report presented within 10 days on the particulars, if at all, the particulars of the allegations, if at all they have been proved or not proved. The writing of this report, and we submit with humility, is to ensure that two fundamental things are done. First is that the other members of the Senate are properly informed of the allegations that have been substantiated. And secondly, to grant an opportunity to the deputy president or the president who is facing an impeachment motion the opportunity of understanding in full flavor the accusations that have since been substantiated, to permit them the opportunity of answering substantively to all the questions that have been, or all the allegations that have been made against them. In this case, as it were, when the Senate on the 9th day of October 2024 decided to interpret Article 145.3 in a manner that gives them the discretion of choosing or opting on whether the matter should be heard by the special committee or the plenary. It means that they indeed substituted the place of the special committee with the Senate committee, or the Senate sitting together as a committee. This, in other words, would mean that if, assuming for argument's sake, that the court is to make an inference that the word may, in this case, was or did give them the discretion of choosing, then it therefore means that a very crucial step that is required under law was missed by the Senate at the point of deciding that the former Deputy President, His Excellency Rigathi Gachagua, should be impeached from office. And this step, my lords and my lady, is that of tabling a report for the purpose of furnishing the respondent with sufficient notice on the allegations that have been substantiated. So, my lord and my lady, the argument that we make is that to the extent, my lord, that the plenary or other members of the Senate proceeded to hold that 5 out of the 11 grounds had been substantiated without affording the first petitioner an opportunity of answering to the grounds that had been substantiated. That in itself meant that a crucial step dictated under Article 145 of the Constitution was missed. My lord, as I mentioned earlier, that the reading of the Constitution as a document that is always speaking to us should be taken to be speaking to us with clarity. This is to mean that if we are to assume that the word may, as indicated under Article 145.3, does not place an obligation on the Senate to form a special committee, then it therefore means that, as it were, and as we find ourselves in, we get ourselves confused, because one would wonder if, in the absence of this special committee, why will the Senate then be writing a report to itself? If we are just to allow the interpretation as was made of this article by the Senate to succeed, why then would we permit or allow a situation like that to succeed? My lords and my lady, your brothers and sister at the Court of Appeal, over and above borrowing the jurisprudence of from the Supreme Court of India, had the following to say. And they noted that the court, as this court is called upon, has a duty to examine the scheme of the Constitution, the purpose and the object underlying the provision, and, with emphasis, my lords and my lady, the consequences likely to ensue if the provision is interpreted one way or the other. So that, my lord, as you retire to the privacy of your chambers to write a reasoned judgment on this issue, we pray with humility that you return a finding that indeed, for the sake of posterity, it is indeed incumbent on the Senate under Article 145.3 to, by law, establish, when invited, a special committee to consider whether the allegations made by the National Assembly or the mover of the motion by the National Assembly, in this case, the Honorable Mutuse, was, number one, investigated, number two, whether there was substance in the motion for the removal of the first petitioner before the Honorable Court. So, my lords, without saying much, I will yield the floor to my colleague, Ms. Waithera, to also highlight a few issues that I may have missed out. That is all from me, my lords and my lady. Thank you.
Thank you.
If it pleases my lords and my lady, my name is Wanjiko Waithera for the 9th petitioner. I will take over from where my senior and colleague has left out. My lords and my lady, Article 259 of the Constitution is the bedrock of constitutional interpretation, and it requires that the Constitution shall be interpreted in a manner that promotes its purpose, values, principles, and advances the rule of law, and human rights and fundamental freedoms of the Bill of Rights. Further, it shall permit the development of the law and contribute to good governance. My lords and my lady, relying on the Court of Appeal decision of the Attorney General versus the Law Society of Kenya, 2019, the court emphasized that the principles of, that in interpreting the Constitution, we have to look at the holistic interpretation of the Constitution, such that the various chapters and articles of the Constitution are read as one document and not as disjointed sections where each provision is destroying the other. Further, the court noted that all provisions have to ultimately be in harmonious symphony. The Supreme Court, in the decision of the Kenya National Commission on Human Rights 2014 EKLR, defined the meaning of what holistic interpretation of the Constitution is. And the court noted that the Constitution has to be taken in context. It is the contextual analysis of the Constitution, reading it alongside and against other provisions, so as to maintain a rational explication of the Constitution, meaning that the history of the articles has to be taken into consideration. My lord and my lady, we have raised two substantial issues in the impeachment process. And the first one is whether the nomination of the deputy president can be legally finalized or approved in absence of a fully constituted IEBC. Taking a reading of Articles 82 of the Constitution together with Article 88, which enumerate the functions of the IEBC to include regulation of the process by which parties nominate candidates for election and monitoring compliance relating to nominations of candidates. My lords and my lady, the two provisions, and by extension the IEBC, provides electoral oversight and approval of candidates for nomination. It is not in dispute that at the time when the second interested party, Honorable Professor Kithure Kindiki, was nominated for the position of the deputy president, there was no properly constituted IEBC, with various commissioners having either resigned or retired. The Supreme Court recently, in the decision of IEBC versus AG, an advisory opinion 2025, sought to draw a clear distinction on what the administrative roles of the Secretariat and constitution mandate of the IBC ought to be. And the court noted that it is our considered view that the exercise of constitutional functions expressly reserved for the Commission, such as those enumerated under Article 88(4) of the Constitution, cannot be lawfully discharged in absence of a properly constituted commission with the requisite quorum as contemplated under Article 251 and 252 of the Constitution. My lords and my ladies, it is our humble submission that the nomination of the second interested party ran afoul the provisions of Article 88 as read with the 82 of the Constitution. We submit that the principles that the court articulated that the commission must be properly constituted cannot have been discharged in order for the IBC to discharge its mandate, has to be held in equal, if not greater, force when it comes to approval of the second highest position in the executive of the Republic of this country. My lords and my ladies, the second issue that I seek to persuade you is whether the nomination of the second interested party, while serving as a cabinet secretary, violated provisions under Article 148 as read together with Article 137 of the Constitution. It is not in doubt that at the time of nomination and even approval of his role as to take over the role of the Deputy President, Honorable Professor Kithure Kindiki was serving the people of the Republic of Kenya as a Cabinet Secretary for Interior. My Lord, by its definition, a state officer under Article 260 of the Constitution includes persons holding the position of Cabinet Secretary. He had neither resigned from this position at the time when Parliament approved his nomination. My Lord, Article 149 of the Constitution cannot be read in isolation. It has to be read together with Article 137, 2B, and 148, 1. And the only exception that the Constitution provides for persons who can be nominated for the presidential position are people who are already serving as a president, a deputy president, or a member of public. None of these positions, the second interested party was not serving any of these positions. And therefore, we humbly submit that a person who already holds a position of cabinet secretary at a time of nomination as a deputy president does not satisfy the constitutional qualification set out in Article 137 2B as applied through 148. And therefore, the nomination of the Honorable Professor Kithure Kindiki runs averse the said provisions. My lords and my ladies, via our petition, that is petition number 565 of 2024, we had sought the following reliefs. The first one is a declaration be and is hereby issued that the rights and fundamental freedoms of the first petitioner, including his rights and freedoms under Article 25C, 50, 27, 47 and 145 were grossly violated by the third respondent on the 17th day of October by declining to allow him an opportunity to adjourn and be heard during the sitting of his removal by way of impeachment. The second relief we have sought is that a declaration be and is hereby issued that the decision by the third respondent to have the first petitioner removed from office by way of impeachment, to the extent that it was done in gross violation of Article 25, 50, 27, 47, and 145, 5, is unconstitutional and null ab initio. A declaration that subsequent replacement of the first petitioner to the office of the Deputy President was also unconstitutional. We've also sought a judicial review of order of certiorari to bring to this court for purposes of quashing the Gazette notice by the third respondent dated the 17th of October, communicating the removal from office of the Deputy President of the Deputy President by way of impeachment. A judicial review of certiorari does hereby issue to bring to this court for purpose of quashing the decision of nominating Professor Kithure Kindiki as the Deputy President of the Republic of Kenya for failing to meet the qualification under Article 137(2)(b) and 3 of the Constitution. In the alternative to that fifth prayer, we have sought that the Honorable Court does make a declaration that the appointment of the Deputy President to fill vacancy arising from the removal of the first petitioner from office pursuant to Article 149 of the Constitution must be read together with Articles 82 and 88 of the Constitution to give the IEBC its constitutional mandate of approving the name of the nominee as proposed under Article 149 of the Constitution. We have also sought a declaration be made that the approval of Professor Kindiki or any other person as the Deputy President of the Republic of Kenya is subject to Articles 82, 88, and 137 of the Constitution. We've equally sought cost of this petition. My lords and my ladies, I have refrained from regurgitating what fellow counsels for the petitioners highlighted in respect to the impeachment processes and the violations that we witnessed therein, including public participation and the violation of the right to be heard by the first petitioner. All those are contained in our submissions. That is all, my lords and my ladies.
Thank you.
If it may please you, your lordships.
It's me, I don't know.
I remember Mr. Kibe had said that for us who had booked 10, 20 minutes, we can go ahead because he has a long time. I believe that is what when we spoke.
We are following the order, and I'm next. You are 58.
It's okay. You can take the floor.
If it may please, my lords and my lady, the appearances for the 10th to 41st petitioners are as previously indicated. For purposes of the order of submissions, my lord, I'll take about 1 hour, 15 minutes. My learned colleagues, Mr. Martin Kamwaro, he has indicated he needs about 25, 30 minutes. And then Mr. Peter Koira, he will take about 10 minutes. So if we could start right away, I think the first thing is our submissions have been furnished to the court alongside a book that we thought it is easier to give the book by law monthly because of what it covers. We thought it is easier to give it as a book. I've given Professor Muigai and Senior Counsel Paul Muite. So, be that as it may, we shall be referring to those submissions. The rest of the advocates we are annexing in our submissions. Yes, relax. The relevant passages of the book are in the submissions. Now, my lords, for purposes of taking the process forward, I think the first thing we want...
These documents, these books,
yes.
Are they given as part of the court record or given to us as individuals?
Part of the record. We have referred to those books.
Part of the court record?
Part of the court records, yes.
And then after that?
You can keep or donate.
Okay.
It's part of the record. I could have photocopied it, but it was going to take a little bit longer. We have been running short of time. But we have referred to it extensively. The parts that are relevant have been referred to in our submissions.
All right.
My lords, be that as it may.
My lord, with your very kind permission, I would really not have wished to interfere with my learned senior friend, Mr. Kibe Muge, but just the same concern that the court is raising. We've just been served with these written submissions. Whereas we don't have a problem with going through them quickly and getting to follow what Mr. Kibe Muge will be saying, he says there's also, in addition to this, a book that he'll be referring to. It is expected that after he's done, we'll be taking the stage. We've not seen this book. I think just one copy has been given to Professor Gido. It would only be fair that we have access to all these documents so that when he's done, at least we'll have had an opportunity to look at what he'll be making his submissions on.
We have referred the 3 passages from the book. I can direct him to the paragraphs where the book is referred to.
I think it's only fair that we get copies, so that then we don't get into a situation where...
I can't afford to give everybody a copy.
He can't then choose to come to court and say, I'll give this book to certain people, certain parties, and not others. That cannot honestly be.
I think to save time, Mr. Mugai, you can just detail somebody to get copies.
Yes.
Yes, so that we can
Thank
proceed.
you, my lord. We shall get them
of the relevant pages.
Yes.
Of the relevant pages.
Actually, they are cited. They are just 3 passages that are cited. The rest is for somebody who wants to read the broader picture. Just like Hamilton's Federalist number 65 has been quoted a single passage, but anybody can read the entire Federalist 65. So it's a simple issue, really. I hope this cannot distract me, so I can proceed. And just for the record, I had spoken to my learned colleague, Mr. Professor Ojienda, Senior Counsel, and we reached an MOU that any points of information and points of order to be spared from me for today. So I hope I can make my presentation as quickly
My
as
Lord,
it
I
goes.
think this matter is not being given the seriousness it deserves. Mr. Kibe Mugai told you that book is part of the record, which means the entirety of the book has been filed. Unless it is on CTS, and unless every party has been given a copy, whether in original or in photocopy, it cannot be part of the record. And it cannot be done to say, I looked through the bar, I saw some people, because they are professors or they have this teacher, I have decided those few are the ones that will give a book he wants to be on the record. A book we might never even have the time to cross-check, so it cannot be on the record. And we are not raising this as a frivolous point. That's just not how we do business. It has never been done that since the birth of the common law, 1076 AD. It is litigation. You want material on record, every party must have a copy of that material. Thank you, my Lord.
Why don't you then wait for him to set the background, and if he makes any references which you are not satisfied with, then you raise an objection? Because at this stage, I don't know where this book comes in.
You see, my Lord, the problem I have is these proceedings may not end here. So if that book is part of the record and we don't have it, when the record of appeal for the next level is prepared, when the court ceases to consider that material, that's what I'm saying, it means something to say that a document is part of the court record. What I would have had him to say if he was doing this thing properly is he would have told you, I am seeking leave from you to put this material on the record, and I will serve it on all the council and all the parties, because that's how things are done.
I think I heard your lordships, the presiding judge, saying that we should photocopy the book and avail everybody, and that is being done, and the book is already referred to in our submissions and in our list of authorities. So I don't know whether this should be said in all local languages or it's sufficient that one is enough, because you have already given a direction.
I think, Mr. Mugai, what you need to do is to avail the specific pages you have referred to.
Actually, I'll photocopy all of it and upload. That is the only thing remaining. My assistant Sylvia is here. She's organizing for that to be done. So before, and we shall start with serving Mr. Mudomi. Actually, his copy should be brought. So we shall bring all these issues to court. There is no big deal. You've given the directions. We photocopy the book. It's a small book. We shall photocopy. Sylvia is already doing it.
Proceed, please.
Yes, thank you, my lord. My lord, as I've indicated, the pleadings in this matter have been referred to. This is a very small space, so we may not have any time to refer to pleadings. Huh? So the pleadings, they are in my bag there. So the pleadings are referred to in paragraph 2 of our submissions. This is at page number 5. Having now said that, I think the next important things to say is who are the 10th to 41st petitioners. My lords, petitioners number 10 to 40 are public-spirited Kenyans, but more importantly, they describe themselves as part of the political constituency of the first petitioner in this matter. This is an impeachment, and impeachment from the High Court, Court of Appeal to the Supreme Court. We've had passages in the judgment saying it is a political process and it concerns political matters. They are the part of that constituency. The 41st petitioner, Gemawadho Association, is an association of lawyers from Mount Kenya region who are over 1,000 and who are also part of this petitioner to try to seek justice with regard to the impeachment that occurred against the first petitioner. Having said that, my lord, I wish to say that it is my great privilege to appear before a 3-judge bench of the High Court under the 2010 Constitution. I believe that matters. I had an occasion previously to appear before similar benches, but under the old Constitution. So why does it matter that we are appearing under the current 2010 constitutions? My lords, as we have argued in our submissions, it matters a lot that justice in this case is required to be administered in accordance with the 2010 constitutions, because this constitution does 3 things. This constitution makes the fundamental Bill of Rights as a fundamental issue of justice, including rights like the right to fair hearing, issues like torture, that are absolutely protected by the constitutions. Number 2, it matters because, unlike the previous constitutions, it gives an elaborate framework in which all the arms of governments are supposed to be held accountable and to operate in a manner that is in conformity with Kenya's status as a constitutional democracy. We have set out what a constitutional democracy is and what it pertains, and what justice in a constitutional democracy ought to be. And issue number 3 is that we appear to this court with a lot of privilege for the simple reason that the Constitution says that the courts, and in particular, I dare say, the High Court, is a guardian of the Constitution. So to the extent, therefore, that it is the petitioner's case that the proceedings before you were carried out in such a manner that constitute violations of constitutional democracy in Kenya, and under rules applied in a manner that makes a mockery of why in the first place we have a new constitution, then we shall be expecting that this honorable court will ensure that the constitutions of Kenya is not in any manner whatsoever violated, because there were very good reasons why we have that constitution in the first place. A while back, I believe this is 1996, I remember because I was a pupil at Kamau Kuria and Keraito Advocates, Firoz Noroji argued an article, very good, giving 10 reasons why we needed a new constitution. I will mention 3 for purposes of these proceedings. He said, 1, because we had ended up having an imperial presidency in Kenya and an authoritarian leader, contrary to the wishes that were understood that would prevail. Number 2, he said that Parliament had ceased to represent the people of Kenya and had become sycophantic, and the people of Kenya in political matters and in public affairs had no political representation whatsoever by Parliament. But more importantly, my lords, he said that there was the failure of the courts, and this was the failure of the courts to ensure that justice was administered in accordance with the rules of civilized democracies. This failure of the courts is an important one. And where did the courts fail? I think when I'm talking about the High Court, it is important that this point is made very clear. Modhomi Thiankuru had talked about the common law tradition. We got it from England. What happens and what we got from England is a notion of having a High Court under the adversary justice system, fair system of justice, administering impartial justice based on law and evidence, and the applications of them to specific circumstances. In England, my lords, I believe most of you are aware of that, the full title of the High Court is a High Court of Justice. It is regrettable ours is just called the High Court. Probably it should also go by the full name, the High Court of Justice of Kenya. Why does that matter? It matters from our history, my lords, for the simple reason that when we said, and when, for example, Firoz Noroji wrote about the need for a new constitution because the courts had failed Kenyans, who failed? My lord, justice in any country and justice in the context of our constitutions can only fail if it fails in the High Court. If justice does not fail in the High Court, you are more likely to have a viable constitutional democracy. It doesn't really matter what happens before the appellate courts. The Court of Appeal, the Supreme Court. Those are appellate courts. They decide justice on the basis of what the High Court has decided. That distinction is absolutely clear, because ultimately, my lords, when the Constitution says that the courts are the guardians of the Constitution, ultimately, and you're aware of 165, Article 21 to 23, and Article 258 of the Constitutions. Just the nature of the jurisdictions of the High Court is to ensure that the High Court can be able to discharge its constitutional role as the guardian of the constitutions. Everybody else, all the other courts on top, decides based on what the High Court has interpreted its mandate to be. And it is on that opening basis that I would want to impress and persuade your lordships that for this very important matter, justice cannot afford to fail before the High Court. My lords, I believe the law reports would confirm that I have been involved in numerous matters of constitutional importance. This is one of the 5th in my book that I believe is the 5 most important cases in this country heard by the High Court. It is important I mention them. In the year 2013, we had the High Court decision in the ICC eligibility case against President Uhuru Kenyatta and President Ruto. That was in 2013. It decided matters that are absolutely important, as we shall be coming to refer to you, and set the stage of ensuring how high voltage political matters ought to be adjudicated upon. Number 2, my lord, we had the famous Maina Kiai case. Everybody in Kenya, including lay people, know about Maina Kiai. Sovereignty of the people is exercised as a polling stations. And we had subsequently the BBI case. We all know the significance of the BBI. The basic structure is an important part of our constitutions. Then, my lord, we had the High Court decisions that would go up to the Supreme Court concerning the budget for the 2023-2024 financial years. Those decisions, for better or for worse, are critically important for purposes of jurisprudence of the Kenyan High Court as a guardian of the constitutions. This is the 5th most important case in my book as far as jurisprudence is concerned in the High Court. And my lord, as it were, just like I stand here today, probably I should have started by saying, you stand on the basis that there could have been another 500 or so.
Naam, mtazamaji, ni kesi ambayo tunaifuatilia ya kubanduliwa kwa aliyekuwa naibu rais Rigathi Gachagua. Tunazidi kufuatilia mengi tu ambayo yanakuhusu kwa njia moja au nyingine. Ikumbuke kwamba ni kesi ambayo imekuwepo katika mahakama kuu na ni kesi ambayo inaongozwa na jopo la majaji watatu wakiongozwa na Jaji Eric Ogolla, Anthony Murima na Freda Mugambi. Kesi hiyo inaendelea kwa sasa na tutakuwa tunafuatilia mengi zaidi tukujuze katika taarifa zetu zijazo, lakini hivi sasa nataka tuvuke moja kwa moja hadi katika mji wa Naivasha.